The Supreme Court has delivered its ruling, a decisive 9-0 decision that is already reshaping the legal landscape in every single state across this nation. For anyone who owns a firearm, carries one, or is even contemplating a purchase, this judgment has immediate and direct implications for you personally. The unfolding consequences of this ruling have the very real potential to redefine the scope of your Second Amendment rights permanently and without exception. Before we delve into the details, I have a quick request. Please take a moment to hit that subscribe button right now. Why is this so important? The reality is that a vast majority of firearm owners, we're talking about 90%, often miss crucial legal updates like this one. And here at Senior Pension Guide, I want to ensure you aren't counted among them. This channel is dedicated to translating complex gun legislation and legal decisions into straightforward, easy-to-understand language, empowering you to remain on the right side of the law while ensuring your personal protection. So go ahead and click subscribe, and let's get straight to the heart of what has just transpired. Here's the essential information you need to grasp. The Supreme Court has handed down a unanimous decision, meaning all 9 justices were in complete agreement. This is an occurrence that is exceedingly rare, particularly in cases involving gun rights. This ruling originated from a specific case in a single state, but its authority now extends to all 50 states, every U.S. territory, and every jurisdiction within America. The core of this decision fundamentally alters the manner in which states can implement and enforce specific firearm regulations. More critically, it changes what prosecutors are permitted and not permitted to do when bringing charges against an individual for a gun-related offense. Allow me to clarify this for you. The case in question centered on an individual who was prosecuted under a state law for firearm possession. The precise details of the charge are less significant than the Supreme Court's foundational ruling on how such charges must be processed going forward. The court determined that when states craft gun legislation, they are constitutionally obligated to adhere to very strict, very specific standards. They cannot simply invent rules and expect them to withstand judicial scrutiny. Every single gun law now must pass a specific constitutional test. If it fails that test, the law is rendered null and void. Here's the aspect that has the most direct impact on you. This latest ruling builds upon a landmark Supreme Court case from 2 years prior known as New York State Rifle and Pistol Association versus Bruin. That pivotal case established that gun laws must be consistent with the nation's historical tradition of firearm regulation. In essence, if there is no historical precedent for a particular type of law from the era when the Second Amendment was ratified, modern states cannot simply create such a law out of whole cloth. Now, this new 9-0 decision takes that foundational principle and significantly strengthens it. The Supreme Court has effectively issued a directive to every state, every city, and every local government. They must now provide proof that their gun laws align with historical traditions. If they are unable to furnish this proof, the law in question is subject to being overturned. Let that sink in for just a moment. States are now required to do their historical homework before they can place restrictions on your right to bear arms. But here's a particularly impactful aspect that many people are overlooking. This decision doesn't only apply to newly enacted legislation. It applies to laws that are currently active and on the books right now. This means that thousands of gun laws nationwide are suddenly subject to legal review. If those laws fail to meet the established historical standard, they can be challenged and potentially struck down entirely. We are talking about a wide range of laws, including those governing where you can carry a firearm, the manner in which you can carry, the types of firearms you are permitted to own, and even regulations on how you store your weapons in your own home. Let's use a practical, real-world scenario to illustrate this point. Imagine you reside in a state that prohibits carrying a firearm in any public park. Under the previous legal framework, that law might have remained in effect simply because the state justified it as a measure for public safety. However, under this new Supreme Court standard, the state is now compelled to demonstrate that analogous laws existed back in the 1700s or 1800s. If they cannot unearth historical evidence of bans on carrying firearms in parks, that current law is constitutionally unsound, and you would have strong legal grounds to challenge it in court. Consider another situation. Suppose your state requires you to demonstrate good cause or a special justification to obtain a concealed carry permit. Perhaps they mandate that you prove you are in specific danger before they will issue the permit. As you may recall, the Bruin decision already deemed that type of requirement unconstitutional, and this new unanimous ruling serves to reinforce that principle with even greater force. States simply cannot force you to plead for permission to exercise a right enshrined in the United States Constitution. If you're finding this information valuable, just imagine what you'll gain from our upcoming content here at Senior Pension Guide, which will reveal the 5 specific words that can protect you during an encounter with law enforcement when the topic of your firearm arises. Make sure to subscribe so you don't miss it. Knowing those 5 words could be the critical difference between walking away a free person and finding yourself in a very serious legal situation. Go ahead and hit that subscribe button now. Now let's discuss the tangible, real-world implications of this for everyday gun owners like yourself. First and foremost, if you have ever been refused a gun permit, denied a carry license, or told you are prohibited from carrying in certain locations, this decision provides you with a much stronger legal foundation to push back. You can now directly cite this Supreme Court ruling and demand proof that a given restriction has deep historical roots. If the state cannot meet that burden of proof, you have a compelling and defensible case. Secondly, this ruling is poised to trigger an avalanche of litigation across the country. Gun rights organizations are already preparing to mount legal challenges against laws in states such as California, New York, New Jersey, Maryland, and Massachusetts. These states are home to some of the most stringent gun regulations in the country, and a significant number of those laws are now highly vulnerable to challenge. We're talking about potential legal battles over assault weapon bans, restrictions on magazine capacity, red flag laws, and limitations on where you can legally carry a firearm. All of these are now open to being contested under this new and powerful judicial standard. Thirdly, and this is a major development that deserves special attention, prosecutors now face a significantly more difficult task. If they intend to charge you with violating a gun law, they must first establish that the law itself is constitutional under this new historical test. This means a higher likelihood of cases being dismissed, charges being dropped, and more gun owners potentially avoiding conviction if the law they are accused of breaking cannot withstand judicial scrutiny. But wait, there's another crucial element you need to fully understand. This decision also fundamentally alters how judges are required to interpret gun laws going forward. In the past, some judges would go to great lengths to uphold gun restrictions. They often employed a method known as interest balancing, where they would weigh your Second Amendment rights against the government's asserted interest in public safety. The Supreme Court has now explicitly and unambiguously stated that this approach is constitutionally incorrect. Judges are no longer permitted to simply balance interests and rule in favor of the government. They must adhere strictly to the historical test. Period. Full stop. Now, a brief but important legal note. The information provided here is for educational purposes only and does not constitute legal advice. You should always consult with a qualified attorney regarding your specific situation. Every case is unique, and you need a legal professional who thoroughly understands the laws in your state and how this Supreme Court ruling applies to your particular circumstances. Let's dissect the historical test so you have a clear and precise understanding of how it works in practice. When a court now evaluates a gun law, it must address 2 primary questions. First, does the plain text of the Second Amendment cover the conduct in question? In other words, does owning or carrying a firearm fall under the protection of the Second Amendment? The answer to this question is almost invariably yes. Second, is there a historical tradition of regulating this specific type of conduct? This is where the burden falls squarely on the states. They must delve into historical records, old statutes, and legal cases from the 1700s and 1800s to find evidence of similar restrictions having been in place. Here's the part that is often overlooked by mainstream commentators. The reality is that most states will struggle, and struggle significantly, to meet this burden. Why? Because during the era when the Second Amendment was ratified, there simply weren't many gun laws in existence at all. People openly carried firearms as a matter of daily life. They carried concealed weapons without permits. Systems like background checks and formal licensing processes were completely non-existent. This historical reality means that a great many modern gun laws lack any historical parallel whatsoever, rendering them constitutionally suspect under this powerful new legal test. Here's a common misconception that many people have when they first hear about this ruling. Some believe that this decision signals the end of all gun laws in America. That is not an accurate interpretation. The Supreme Court has affirmed that certain types of restrictions are still permissible, such as laws prohibiting felons from possessing firearms or laws banning guns in inherently sensitive places like courthouses. However, the critical point is that even these permissible restrictions must be backed by genuine historical precedent. States cannot arbitrarily designate new sensitive places or create entirely new categories of people prohibited from owning guns without solid, documentable historical support. Did you know that a significant percentage of viewers watching right now aren't yet subscribed to Senior Pension Guide? Don't let that be you. Become part of our growing community of informed gun owners who receive these critical updates first. Click subscribe. The coming months will bring even more significant legal developments, and you genuinely won't want to miss a single one. Now let's address the timing and what we can realistically expect going forward. This decision has just been released, which means we are in the very early stages of observing its full impact and reach. Over the next 6 to 12 months, anticipate a surge of legal challenges to gun laws in virtually every state in the Union. Some of these lawsuits will be successful, others will not, but the overarching direction is unmistakable. The clear trend points toward an expansion of gun rights and a significant contraction of government-imposed gun restrictions. Here's another concrete hypothetical to help explain this further. Suppose you live in a state that prohibits carrying a firearm within 1,000 feet of a school. That's a fairly common type of law across the country. Under this new Supreme Court standard, the state must prove that similar proximity restrictions existed historically. If they cannot, that law becomes constitutionally untenable. The federal government has a comparable law that has already been challenged before, but this new ruling provides challengers with even stronger, more clearly defined arguments. Another example worth considering: some states mandate that you complete a training course before you can obtain a carry permit. Is that constitutional under the new test? It's conditional. If the state can demonstrate that formal training requirements were present in the 1700s or 1800s, then it might survive scrutiny. But if there's no historical evidence, and for most states there won't be, then that requirement could very well be invalidated entirely. Most states will simply be unable to prove that such mandates existed back then, placing those laws on very unstable constitutional ground. This is the aspect that resonates most deeply when you really think through the implications. Even laws that appear entirely reasonable and grounded in common sense must now pass this rigorous historical test. It is irrelevant whether a law sounds like a good idea or whether it might potentially save lives. If it lacks historical roots, it is unconstitutional. This represents a truly monumental shift in how the entire judicial system must approach gun cases going forward, and it stands as a major, undeniable victory for Second Amendment advocates everywhere. But this is where it gets even more complex in the near term. Not every court will apply this test in precisely the same way. Some judges will adopt a strict approach, demanding very clear and direct historical evidence. Other judges may be more flexible, accepting broader historical analogies and parallels. This variance means we will likely see differing outcomes in different courts across the country, and eventually some of these cases will make their way back up to the Supreme Court for further clarification and refinement. Now let's focus on what concrete actions you should take right now today. First, if you reside in a state with stringent gun laws, pay close and consistent attention to the legal challenges unfolding in your area. Organizations dedicated to gun rights, such as the Second Amendment Foundation, the Firearms Policy Coalition, and various state-level groups, are filing lawsuits with increasing frequency. Some of these cases could have a direct positive impact on you by striking down laws that currently restrict your rights. Second, if you have ever been denied a permit or are currently facing a gun-related charge, you need to speak with a qualified attorney immediately. This new Supreme Court decision could be the pivotal factor in getting your permit approved or having charges against you dismissed. Do not simply accept the government's position as correct and final. Challenge them and force them to prove that their laws are constitutionally sound under the new historical standard. Third, and most importantly, stay informed. The legal landscape is shifting rapidly, extremely rapidly. What is considered legal today could be meaningfully different tomorrow. Stay connected to Senior Pension Guide, follow the work of gun rights organizations, and keep yourself updated on legal developments specific to your state. Knowledge is power, and in this context, it is the key to staying protected and out of legal jeopardy. This information could become time-sensitive, especially as we approach critical dates in the near future. Subscribing now is essential because the next video we release will detail exactly what you need to do before upcoming legal deadlines. Significant changes are on the horizon in the coming months that will impact millions of firearm owners across the country, and you need to be fully prepared. Here's the fundamental takeaway from everything we've covered today. The The Supreme Court has issued a unanimous decision that significantly reinforces your Second Amendment rights while simultaneously limiting the government's capacity to impose restrictions on firearms. This ruling is applicable in all 50 states and will undoubtedly catalyze major revisions to gun laws nationwide. If you own or carry a firearm, this decision is advantageous to you, but you must understand how to leverage it effectively and responsibly. Now for the concluding point. This decision represents a significant and historic victory, but the broader struggle is far from over. Political figures and advocacy groups opposed to gun rights are already strategizing on ways to work around this ruling. They will either scramble to find historical evidence to support their existing laws, or attempt to craft entirely new legislation they believe might pass the constitutional test. This is precisely why your vigilance and continued commitment to staying informed are so absolutely vital right now. So here is my final request. Hit that subscribe button and enable notifications so you never miss an important update from Senior Pension Guide. Please share this video with other gun owners who need to be aware of this landmark decision, and leave a comment below telling us what state you call home and which specific gun laws you would most like to see legally challenged. We read every single comment, and your input is invaluable in helping us decide which topics to cover next. Remember, this content is for educational purposes and is not a substitute for professional legal advice. If you are dealing with a legal issue, you must consult with a qualified attorney in your state who possesses expertise in gun law and fully understands the nuances of this new Supreme Court ruling. Every individual situation is unique and requires personalized professional guidance. Thank you for watching, thank you for being a subscriber, and thank you for being an active and informed member of this community of responsible gun owners. Stay safe, stay within the bounds of the law.